Good morning, everybody. Can the live feed hear? Is the audio working? Perfect. Thank you very much. First of all, welcome everybody to Nashville. Appreciate everybody tuning in online, as well, most importantly, the folks who came to Nashville to join us in person. It's been a couple long years, and Wires has been very focused on having in-person events, and this is the second one that we have had recently. So thank you all for taking time to join. We really do appreciate it. Most importantly, I'm very excited to welcome our distinguished guest today, Commissioner James Stanley. James, Commissioner Stanley, as we all know, has kind of a distinguished record before coming to FERC. Part of that was serving as a law clerk for the Sixth Circuit. The judge that he served with, that he clerked for, most interestingly, has an energy background as well. So Judge Danny Boggs served on U.S. Department of Energy as a deputy secretary, as well as even was a Federal Power Commission assistant to a chairman. So back when FERC was a Federal Power Commission. Commissioner Stanley has kind of early experience with FERC matters, even before coming to FERC. Commissioner Stanley is also a former U.S. Army officer, served 2 tours of duties in Iraq, and was awarded both a Bronze Star and a Purple Heart. He was also the former general counsel at FERC before assuming his current job. And that's really where I had the pleasure to start getting to know Commissioner Stanley, and it became really abundantly clear that Commissioner Stanley has a keen interest in really the integrity of the statutes that govern FERC, particularly the FPA was some of the discussions I had with him at the time. And it is certainly, we've seen this time and time again, and Commissioner Stanley's tenure at FERC, and really this placing of importance on the integrity of the statutes, and something that we really appreciate. Most importantly, Commissioner Stanley really knows what it takes to build transmission, and part of that is stability, predictability, and underpinning all of that is ROEs as well. So he's fantastic background in knowing what's most important to these members, which is how we build transmission. So with that, we'd love to welcome Commissioner Stanley up to the stage, as well as Larry Gastiger, the Executive Director of Wires. It's going to be a round table, or it's going to be a kind of fireside chat format, and please don't be shy about asking questions. So thank you, Commissioner.
Thank you. Yeah, it's a fireside chat without the fireside going on, but
or the leather chairs.
Exactly. I said we don't want you to get too comfortable up here. So, but at least it's not stools, right?
No.
But in any event, I want to welcome you to our meeting. Greatly appreciate your taking the time to come and join with us. And I know our group is really interested in hearing your thoughts broadly on transmission, but in particular on a number of different areas. And the timing of this meeting was pretty fortuitous, but entirely by happenstance, I have to say. But following shortly in the aftermath of the issuance of the notice of proposed rulemaking by the Commission last week, focusing on transmission planning and cost allocation. And I think I'd like to just start, if we could, with generally what your thoughts were with respect to the Commission's undertaking. I know you dissented from the order. You wrote separately, so you have a very different perspective from the rest of your colleagues. And I think from our group's perspective, we'd just like to hear, at least at a high level, your thoughts on the rulemaking and what you anticipate in terms of the next steps in the process.
Sure. So that's right. Last week we issued the NOPR on transmission, and it was a 4-1 vote. I was the sole dissenting commissioner on it. I had voted for the ANOPR, and I'm usually perfectly fine beginning generic proceedings. What's usually the problem in asking questions and trying to find out what people think about something, contemplating this or that reform in various parts of our jurisdiction. But in this particular case, I had a couple of real problems with it. The first one was I truly doubt, and I'm happy to be proven wrong on this, which will bring me to one of the points I'll make repeatedly over the next few minutes, which is please file comments. I'm happy to be convinced otherwise, but I really doubt that we're going to be able to build the kind of record necessary to make the first Step 206 finding required to impose coercive further transmission planning requirements. So I say that in the full knowledge that we have had courts uphold fairly broad actions before on a generic basis. And when you think about all the landmark orders, you understand why it is that the NOPR as written purports to be in the great tradition of 888 and 890 and 1000 and 2000, right? It claims that heritage. And to a degree, it does, right? It certainly is a further iteration of the transmission planning requirements. But if you look, for example, at what 888 did, it said, we're not doing this to promote particular public policies. We're not doing it to keep rates low. We see a clear indication across the industry that there is a undue discrimination based upon the inability of generators to get their power to ultimate consumers. That is very much in the heartland of what the Federal Power Commission's original task was, right? That is the very purpose for having this Commerce Clause-derived statute to allow for trade across state lines and the like. As time went on, though, and these landmark orders, I think they became more and more untethered to the actual core purposes of what we're doing. And I acknowledge that Order Number 1000 was upheld on appeal, but if you pause to think about some of the reasoning for why it was upheld, that the Commission satisfied its obligation to make its decisions under Section 206 on substantial evidence because the Commission showed substantial evidence of a theoretical threat, that strikes me as being an extremely weak endorsement of the reasoning of the order, which is not to say that the order was necessarily infirm. I'm just saying that basis theoretically is not wholly convincing to me. Let's consider what in my conception of 206's requirement, what would be required to be shown to impose a transmission planning system that is universal and has as little flexibility and variation as I think is being contemplated. You obviously have to take time to digest 450 pages, so not I would understand if people are still trying to catch on to the exact implications of it, but I think that you would have to show that the rate, because it dresses itself up in terms of rates, right? It talks about rates. It makes the necessary gesture towards the rate requirements, the same way Order Number 1000 did. You would have to be able to show me that disparate regions of the country which have different utility systems and different methods of planning transmission and conducting their operations of utilities, broadly speaking, have such problem with proper transmission rate formation that it justifies action on a universal basis because of a systemic problem. Well, if that's true, why would it be that certain regions, you can think of certain parts of the country like the Southeast, have remarkably low transmission rates, and other areas, especially those that seem to have an awful lot of oversight from the federal government, I can think of particular RTOs in mind, have very high transmission rates? What exactly would be the theoretical basis? What would be the data that you would show that would actually say that what you're doing is remedying a problem? So that's the first thing. I don't think we're going to have the showing. Again, though, file, prove me wrong, give me hard numbers. One of the things you'd be surprised by is just how hard it is to get those hard numbers out of people. I'm worried that we're eventually going to be coming to a final rule that's based upon a bunch of first principles and logical deductions from the first principles, and I don't think that's good enough to discharge our duties. There's a second problem here, which is that even though it made those references to, if you remember Order Number 1000, I'm not going to get the words exactly right, but it says, there's substantial build out and we're concerned that there's going to be, in the future, failure to keep rates just and reasonable for transmission, so we want to have a planning process. That was the basic gist at the beginning. Well, similarly, in this NOPR, we have talk in the beginning of it about what the potential rate implications down the road will be. It then immediately abandons that entire discussion, barely to even glancingly return to it again, and gets immediately into the actual heart of this proposed rule, which is to preference certain public policy choices of certain states and force everybody into planning for those public policy choices. And those public policy choices are, for the most part, the renewable portfolio standards or the like for both states and localities. Something I pointed out in my dissent, which is pretty surprising, the idea that, sure, the states are sovereigns whose planning should probably be thought about, or whose interests should be thought about, but the idea that localities too are going to have to be part, that you have a city and so the entire region has to think about what that particular municipality is doing, that seems to me to be quite a I think that's hard to justify. So, but what it essentially does is it bakes in from the get-go of the transmission planning process that's proposed considerations of specific types of state policies, and then creates a mechanism that sort of presupposes the conclusion that you're going to arrive at, which is that all of the transmission planned has to achieve those goals. Well, first of all, that is not in our mandate statutorily. We are, in fact, a completely resource-neutral agency. We have historically not cared, and it would be my contention that far from avoiding undue discrimination, this actually bakes in discrimination for a certain set of favored policy outcomes. Half of the states don't have renewable portfolio standards. That means 1/2 of the states of America would be forced to be in regions that are planning for other states' objectives. The whole purpose of having federal oversight is to ensure that the depredations of one state do not actually harm or I shouldn't say depredations is a strong word, I'm sorry. The consequences of the public policy decisions of one state, I really do want to withdraw the word depredation. The policy decisions of one state don't cause ratepayers in another state to pay for them unjustifiably, right? And then there's a final point here, and I didn't get into this in my dissent, but I've talked to quite a few people about it, which is that, you know, if you look at regions that have vertically integrated utilities that have low transmission rates that are doing their job well from the standpoint of the commission as the rate policeman, when they engage in their transmission planning both as utilities and then with their neighbors, because they all engage in planning with their neighbors, they always do that, the objective that they have both as individual utilities and collectively as groups is to try to come up with the transmission facilities that will best enhance the existing transmission infrastructure, right? Of course, there are other incentives involved, but that's the purpose. The more we have an Order Number 1000 regime, and everybody rolls their eyes about, you know, Order Number 1000 isn't working. Well, one of the reasons for that is when you have an imposed transmission planning system, and every time you gild that lily with further requirements, the transmission planning process becomes a process by which to satisfy the requirements of the process rather than the most fundamental requirement, which is to properly advance the development of the transmission system. Which isn't to say the guiding principles are necessarily a problem, but I simply want to try to encourage everybody to be skeptical that the purported purpose of these transmission planning regimes is necessarily what's going to be achieved. So that in brief, that more extensively, I think, than you were expecting were my objections to it.
Yeah, and just to follow up on some of your comments, as you mentioned, you not only strongly encourage comments to be submitted in response to this, but you also emphasized that what you would really like to see is almost on a finding-by-finding basis indications of support, opposition.
Absolutely.
What the basis is for it. And then you also mentioned here, too, and I wanted to ask you a little bit more about this, you've pleaded for data.
Yeah.
And I've heard you do that in other contexts as well. And I guess I'd be interested to hear a little bit more of what you've got in mind in terms of data that you would find helpful or persuasive in terms of looking at these issues.
In fact, you know what? I am here selfishly in part to encourage this very purpose, so I'm glad that we're pivoting to my ask, which is this very subject. So, we do not need to necessarily have the level of granularity I would hope for a generic proceeding under 206. I acknowledge this. I nevertheless think that if we're acting in broad strokes where there are regions that are clearly doing well and do not need to have interference, it is maybe unlawful, but definitely bad governance to impose regimes that they don't need. And my worry, as I said, is that we're going to have, like in Order Number 1000, the courts ultimately uphold our decision in a final rule based on a showing of substantial evidence of a theoretical threat. right? That is not, in my mind, a sufficient basis for the coercive action that's being contemplated here. What does that mean? Our statute requires action based upon substantial evidence and reasoned decision-making. Substantial evidence of theoretical anything strikes me as already having left the fundamental requirement of the showing that has to be made. And I'm going to get to the issue of comments in a second, but I'd like to just take an aside for a moment here to talk about that for one more moment, which is to say, let us think about what the Federal Power Commission does, or did when it was originally created, what FERC has inherited. The United States relies upon the delivery of its essential services in a mixture of private entities and public in certain occasions, but it's primarily private. We allow those, in early days, the natural monopoly for the utilities, and we had a policing regime in which we made sure that there would not be monopoly rents charged on the ratepayer, but also that the rates would not be confiscatory for the actual private property owner, right? So there was a balancing act, and this is the oft exalted and oft maligned regulatory compact that people talk about. But always in the background is that the utilities are basically free to do whatever they want as long as they put everybody on notice beforehand and what they propose isn't outside the bounds of reasonable action. And this has a couple of consequences. One of them is the default is that you approve what they put forth because A, it has to be not just and reasonable to be rejected, and B, the default is acceptance because if there's no commission action, it's accepted by operation of law. So that means that the default is that utilities get to do what they want. That's Section 205. You go to Section 206, there has to be an affirmative showing, and Section 206 was always conceived of as a complaint regime. I seek relief against these rates that are not JNR, and I come to you, the adjudicator, and I tell you first that they're not just and reasonable, and second, I propose a replacement rate. And the replacement rate has to be JNR. So, and I realize I'm going back to FERC Regulatory 101, but sometimes in these large generic proceedings in pursuit of specific policy goals, I think that the fundamentals of the statute are a little bit lost here. 206 as a complaint regime doesn't strike me as contemplating, as a standard method of its implementation, vast sweeping generic proceedings that are based on the lack of hard data that Order Number 1000 had. So I acknowledge that it could be that there will be a recapitulation of the same sets of challenges and appeals, and it may be that the commission is upheld. Don't know if that's the way it goes. It would be so much better to inform our decisions if we could get data that is more specific and numerical than we have had so far in the ANOPR. And I understand in the case of the ANOPR, we were before the point of actually having specific detailed proposals, but now you have 450 pages of extremely specific ways in which we're proposing to regulate the world further. And for each, my plea, and I said this in my separate statement, was to have absolutely unambiguously styled comments such that the title of the thing, when you look it up in eLibrary, is comments in opposition or comments in support. And that the comments not get into, as many of the ANOPR comments did, the sort of general planning philosophies that you would love to see and the kind of ideas that should inform the commission's thinking. That has happened. The commission has its thinking, it's reduced it to writing, it's given it all to you, and you're reading it now. What is needed is comments that, to the extent possible, specify for each proposal support or opposition and the reason why, and that track the structure of the NOPR. And part of the reason is that this is going to be a contentious undertaking, and being as clear as possible is helpful because I spend a lot of time wallowing in these records, and it can be hard sometimes to extract exactly what it is that the comments say. And this is simply a plea for the best advocacy possible from the commenters, because you want to have effective comments, and it can be very difficult. And of course, you know how FERC works. We rely on staff to go through these things, and they do an excellent job of reviewing them and encapsulating them. But commissioners have to read the comments themselves too. This is all a big mixture of different avenues by which the information comes. But we have to read the comments themselves. And if they're not clear as to what they're actually saying about the specific proposal, make it easy on the adjudicators by not making them have to extract and figure out by implication what you're trying to say. Now, as to the data, if people could submit a comment in support that says, look at the terrible consequences of our failure to plan properly. Everything in this NOPR is exactly correct, and I'll show you why. Here was a thing that should have happened and didn't. Here is something that we should have done that we failed to do because we didn't take it into account correctly. In hindsight is 2020. But had we had the exact set of rubrics that are being put out here, look, we could have saved the ratepayer X number of tens or hundreds of millions of dollars, whatever it is. That would be perfect. And similarly, if you say, well, wait a minute, they have this area, I'm making this up, I don't know if such a thing exists, but this region actually does 9 out of the 10 things specified, and their rates are 350% higher, despite the fact that they have flatter terrain and a more robust legacy system to build on, and yet our rates are a fraction of that, and we've experienced dramatic load growth at a rate that they haven't. That would be an extremely useful thing too, because it would have numbers that are hard data and we can actually compare. Now, I realize one of the problems here is that different regions, this isn't a problem at all. It's one of the glories of the way that we've set things up. The regional variations are excellent to get data from because you see a bunch of different ways to skin the cat of how you're going to deliver utility services to consumers. One of the problems, though, is that you do get into a little bit of an apples and oranges comparison because trying to compare the outcomes for anything, not just transmission, between a market like PJM and a market like MISO, which are completely different in the way that they're made up, and then even more different than that, a non-market region, can be very challenging. And so I acknowledge that that's difficult. I nevertheless would say remain undaunted and try your best to file things that are as numbers-based as you can.
Well, thanks. That's very helpful. I was just going to say, I think in response to your comment about your plea for a clear captioning of in opposition or support, my guess is you're going to get quite a few that are going to say in opposition in part and in support in
Great.
part. So it's
Yeah.
going to be pretty
I write dissent in part, concur in part all the time. That's perfectly fine.
So let me ask you a little bit about this, because your approach was focused on flaws you thought that really are kind of fundamental to what the commission was doing.
Yeah.
You didn't wind up having to address many of the host of issues that were specifically addressed in the context of the order. And one in particular, I guess I'm interested in just hearing your thoughts on, is the focus on rights of first refusal, where the commission circled back and re-examined an issue. It was teed up, I think, in one paragraph in the ANOPR, maybe a little bit more. So it wasn't central to what was happening there. But the commission took some pretty striking action in the NOPR in connection with that. And I guess I'm just curious as to what your thoughts are about that. That issue's been percolating around now for over 10 years.
Yeah.
Been a lot of debate. It was the source of debate even with Order 1000 itself.
Oh, yeah.
So I guess I'm curious if you could share any thoughts you have in connection with that issue, and generally, I guess, your thoughts on competition with connection with transmission.
I will acknowledge that I too am a little bit surprised that ended up going where it did. If you look at this, there's a suite of proposed, the chairman's talked about this, so I'm not speaking out of school, a suite of proposed transmission proceedings that are going to descend from the ANOPR. And I would have thought that because this subject is so contentious, it would have been dealt with separately, because you could see this really causing an awful lot of problems in an already complicated subject, right? So I have been listening to people argue over the right of first refusal question vigorously for years now. And I think that no matter what action is taken, that vigorous discussion is going to continue apace forever, right? Until the dream of DERs and little countertop Mr. Fusion really becomes a reality. People are going to argue about this as long as transmission's needed. So, Mike, the question I guess I would ask, and I had said before, and I'm embarrassed to go back on it, the time for basic principles is over. We're at a notice of proposed rulemaking. But a moment of principles is worth getting into when it comes to rights of first refusal. They have been around in one form or another for a very long time. They have been challenged, they have been criticized, and it really feels to me at this point that it is more a matter of philosophy and prudential decision-making by a commission to determine, or legislature to determine what they want. What are the promises of, what are the purported promises of competition in the realm of transmission? Actually, you know what? I'll pose the question back to you. What would the purported promises of competition be?
I guess I would say the main focus is the argument, at least, that competition is going to lead generally to lower rates and costs ultimately to consumers.
Yeah.
I think that's the theory.
That is, in fact, the theory. Yes. You don't need to be sheepish. I said, what was the argument? I didn't say, what do you think? So, yes, right? Do we have any evidence of that?
So I guess my response on that would be, how did this turn around into an
No, fine, no. I'm sorry. I'm auditioning
joking.
for your job.
I'm
No.
joking.
So
I'm joking only because I would say after about a pretty extended period of about 10 years, with a lot of theory,
yeah,
we are now actually starting to get some experience.
right.
Where we're seeing what the results are. And I think, to be generous, you're seeing a mixed bag.
I agree.
And we will start to get more of a compilation of instances where competition fully plays out. And in some instances, I don't think it's working out the way people thought it should or would work out.
Yeah.
And you look at what's really happening in terms of rates, questions around how exemptions or exclusions from things like cost caps on them are really working out, how the bidding process is working out. So I think as we start to get more of a record, your data kind of point, it'll give the commission an even clearer picture as to whether this is really working out the way people thought it was going to.
So we are getting information, and who knows, if things continue to the way they're going for another 100 years, we'd obviously get more information. But we have a theory that says prices will go down for consumers if we allow merchant undertakings to supplant a certain percentage of the transmission system, not supplant, but be run by other actors. And the theory sounds pretty good. It's an appealing theory. It's certainly in keeping with the general market impulse that we've had at the Commission for decades now. I would have thought that were it actually as obvious as people would have thought it to have been, there would have been a whole lot more of it, a whole lot faster, which doesn't mean there won't be one or two, which is a total failure. And, you know, all of this involves some risk, and there's going to be outliers and everything. But I have to admit to a bit of skepticism that the industry of transmission is actually one that is as amenable to these market forces as other industries are. I'm not saying that market forces can't be employed, and obviously I'm not saying that given choices between more and less cost-effective answers, you would obviously choose the one that's less expensive. But think about what the effect is on an incumbent utility that has an extraordinarily long planning horizon, right? Incumbent utilities look at things over very long periods. This isn't, you know, what is my 3-year forward obligation? This is, what is the plan that we're going to have to plan the infrastructure that itself takes years upon years to physically build, right? And then you add to it a further level of uncertainty because they're dealing with predictions of where, you know, load growth is going to be or what the effects on the entire system are going to be of introducing another line. And then all of a sudden you add into it another complicating factor. I don't know this, and I would love to know it from people. When you're conducting as a utility that would be subject to that kind of additional outside variable that is now affecting your planning and your thinking and your allocation of the money that you have, how does that actually change the incentives as you see them? And I have not had a sufficient number of discussions with the planners to actually, or the utilities to know that yet. I would love to know the answer. And by the way, if anybody wants to tell me the answer, please reach out to my office and I'm happy to talk to you.
I was just going to say, it sounds like this is leading up to an invitation for people to come in and
please.
talk about.
And by the way,
experience.
I want to actually make that even clearer. So your membership in particular here, I am truly open to people calling my office and talking about generic proceedings. for all the generic proceedings we had before, or also in anticipation of 205 filings. To give an example, I wrote that series of white papers and had dozens and dozens of talks with people about the minimum offer price rule filings that we had anticipated that weren't yet on the record proceedings. Similarly here, I would like anybody who wants to talk to me to call me and talk to me. So you don't even have to have a particular filing, but if you want to talk about what your comments might be or how you might participate in the docket, I am happy to discuss it with you. So.
Well, let me just pivot to a different aspect of the NOPR, which is what's not in the NOPR. And the ANOPR covered a lot of territory.
Yep.
The NOPR then dealt with two of the major items that had been flagged, but there was a third one related to interconnection in the ANOPR.
Yep.
It's not dealt with in the NOPR. I guess I'm curious as to whether you can shed any light on whether or to what extent the commission might be dealing with that issue at some point down the road.
So sorry, I have a bad back, so I have to wiggle a little bit. You are well aware that we do not talk about the nature and timing of commission action. It is no secret, though, that the five of us are every one of us has expressed in various ways and in various levels of anxiety our concerns about interconnection, right? And I've been writing dissents on the subject for a while, often in the context of what I think are illegal retroactive waivers that keep getting granted and keep adding further and further confusion and complexity into management of queues and the like. I don't think there's anybody who thinks anywhere that the interconnection process is working smoothly. I know that there are a number of very thoughtful proposals that I mean, you've presumably looked at many of the comments from the ANOPR. There were many thoughtful attempts to try to police the milestones and ensure that the processes are tighter, to spread cost around for interconnections, which is something I am generally not in favor of, because I think that creates a whole set of incentives that are very problematic. But you know, it's a subject of ongoing discussion. This is as important to the commission as a body right now as the transmission planning is. So the problem is, if with all of the different tariffs that we're dealing with, you'd be hard pressed to find really successful regimes for this. Would you agree with that proposition? Again, now I'm interviewing you, but it's hard. It would be hard for somebody to say, you know what, we found the solution. It is what these guys are doing. Implement that everywhere, right? There are variations of how unsuccessful the process is. I don't think I'm speaking out of school saying that. It's fraught with difficulty. And think about the fundamental challenges that you have here. People have to be able to be part of the system, or they can't deliver. There are a lot of them who are proposing things, many of which will never happen. How do you adjudicate which one of those has to show what indicia at what time? And much like the way our markets have been designed, I think that this is going to have to be an iterative process, right? The idea that you would titrate the cost and incentives perfectly in the first go with any externally imposed regime is pretty unlikely, right? Learning and then tightening things up or loosening them as necessary, I would assume, right?
Great. So we indicated earlier that the commissioner has agreed to take questions from the audience. So I want to put people on notice. I've only gotten through 3 of my questions so far, and I have a whole list.
Yeah, I saw that. I saw that notepad. I was a little worried there.
But so I'm gonna ask one more, and in the meantime, start thinking about what your questions are and flag down Drew so you can be prepared once we get through this one. But these. Unfortunately, none of these questions are simple, and the answers are equally complicated as well. But I want to shift to something that Will had talked about in his welcoming comments to you, which is the importance of and the focus of rates of return on getting investment made in transmission. We all know how critical a piece that is to part of the consideration. I guess without getting into the specifics of any of the pending matters that are before the
there are many of them.
I just want to just generally what your thoughts are or your approach is to ROE methodology, and then related to that, just looking at what the trend has been with the commission, both in terms of its case-by-case assessment of ROE and the trend of the results from that, contrasted with all the talk about needing a lot of investment in transmission that you hear coming from different quarters of the commission. How do you reconcile those two things in terms of the commission's approach?
So the first thing is that we have a fairly clear requirement here that when we set ROEs, we have to set them with the purpose of ensuring that it's attractive enough to get investment. I mean, that goes back to basic case law, right? And you can argue over whether or not those specific numbers in a particular, we're not going to talk about a particular proceeding, but you can argue whether or not that balance was stricken correctly in any particular proceeding. There's a much larger problem, which is that for this infrastructure, which, as I alluded to, requires long planning horizons and a lot of, it needs to have as much certainty as possible in an uncertain, changing system in order to get that investment made. And one of the reasons why we have patchwork quilt of smaller projects sort of holding the thing together with mucilage and duct tape is because that lack of clarity is really stultifying, I think, to a lot of potential investors. The Rube Goldberg machine that we have come up with, I cannot imagine satisfies the requirements of any participant in the use the term as broadly as possible, the market for transmission development. I cannot imagine that it does. Usually people are fairly circumspect in their denunciations of what the commission has done, but this is one of those cases where they're not, and they'll tell you pretty clearly that they think that fiddling around and coming up with what they believe to be and not totally unjustifiably sort of ex post facto justifications for what is a sort of like unjustifiable judgment call. I mean, I've had people really be very aggressive about it before. So I can't believe we're doing that. And also, every time the commission seems to lurch in one general direction or another, higher or lower, that adds yet another layer of uncertainty to the entire undertaking. And I am sure that there is some economist who has done some extraordinarily math-intensive research on, just how bad does a bad price have to be before it is no longer better than continuously changing better prices, right? Because you could imagine that there is some intrinsic value to stability. I'm sure somebody's done that. I've never read the paper. Send it to me if you have it. But I could imagine we are well into that territory at this point with ROEs, right? Are you looking for me to tell you how to fix it?
If you have any suggestions, I think we'd be interested in hearing what your thoughts are on them.
So, file comments. I really think that stability and predictability are critical, and that especially given the mishmash that we've created so far, any drastic departure from even the less than optimal setup that we have now should be undertaken with a great deal of deliberation, because we risk even further confusing things. And you asked the question about how do I reconcile we need to build with what looks like a
generally downward
trend. Yeah. So we can talk about another subject here that's related to it, which is incentives. If you get the ROE right, the incentives are not. If you had a pure sort of hope regime where you're perfectly getting the correct returns, incentives wouldn't be necessary because you completely fell within the four corners of the mandate of rate making, right? As a theoretical matter, I think you would agree with that. Hard to get it perfectly right, and also incentives reflect a certain set of policy considerations that are meant to encourage not merely the investment, but something on top of it. That's a matter for the Commission's determination. I'm probably less enthused about incentives than others might be, because I would rather try to get the ROE right in each case. But there are some incentives, like the RTO incentive adder, that this isn't our policy call, this is Congress's. And I can't, you're going to forgive me for not knowing the exact language from the statute, but it's very broad, saying something like, to the extent consistent with your statute. Well, that's a lot. And these are things where that's what I really find hard to reconcile, is the Commission's move away from even mandated incentives in the middle of saying we need to have as much transmission build out as possible. And the thing is, my first day as a commissioner, or my first open meeting, I said that one of my biggest concerns, in fact, actually, I think you and I may have talked about this after I said it, one of my biggest concerns, because I ran into you in the building, one of my biggest concerns was the failure to build transmission where it is needed, right? That was one of the three things I said when I first showed up, and I still am concerned about it. What I'm worried about is reckless build out for no valid purpose. Valid purposes, in my mind, being primarily for reliability or cost reduction, right? Those are the two fundamental types of transmission projects that we really should be concerned about. Accommodating idiosyncratic public policies is not within the remit of FERC as I view it. Support of that part of Order Number 1000 in the appellate court notwithstanding. So I do find it hard to reconcile those two impulses. If I want to be charitable, though, what I will say is those are always warring impulses within a rate regulator. You want to encourage the development of things while at the same time ensuring that the rates do not overly burden the ratepayers. So you will always, if FERC is doing its job correctly, you are always going to have that tension, right? So it's just that it's not so much the tension that's the problem, is the amplitude of the rhetoric on the 2 points, right?
So let me take a moment to see if anyone out in the audience has any questions for the commissioner. Oh, several.
Oh, I get to go first?
And I should say, by the way, that you can really feel free to ask me whatever you want. I am not shy about saying I'm not going to answer
And
something.
if you could say,
So-
and if you could say your name and who you were.
Can you hear me? Yes, okay.
Yep.
I don't normally need a microphone, as most people know. Thank you so much for coming to our meeting. We really appreciate hearing your thoughts, and it's very helpful for those of us who are working on drafting comments to kind of get a feel for what would be useful. And I guess one of the questions I had is, you indicated in your early comments that you would like more data to support, why we would need changes to the planning process. And at the same time, we were just talking about the generator interconnection queue and how flawed that is, and the fact that there's a lot of generation sitting in the queue, which could actually lower customer costs if it was brought online. So is the queue data, in your mind, just not valid because you feel that there's too much phantom generation, or is that not part of the data that we could use to support a change to planning?
Oh, yeah, it's totally valuable, and you should submit every last jot until you think you can give to us. Yeah, I'm kind of, your question surprises me a little bit, because going back over what I said, I can't imagine why it would be that you would have thought that I wasn't concerned about that. Could you tell me what it was I said, so I don't leave people with the wrong impression here?
I just think that you said we needed to prove that there's an imminent threat to justify sort of making this kind of sweeping change around planning
no,
for
we
renewables.
don't.
Yeah?
No, so I didn't say that.
Okay, sorry.
What we need to do is satisfy the first step of Section 206. I would hope with as much granularity as possible to justify the imposition of a coercive regime by the Commission to tell people how to do things. And I think it's going to be hard to make that showing when some regions are doing it great and others aren't, and having the same system applied to all of them. If it's anything other than a perfect reflection of the region's actions that are doing well, doesn't make sense to me. And the imminent threat part was me expressing my doubt as to the real credibility of the reasoning in support of upholding Order Number 1000, because our statute requires that we take action based on substantial record evidence and we reach our conclusions through reasoned decision making. Those are sine qua nons of legitimate commission action. And I can't understand how substantial evidence of a theoretical threat meets the requirement to base action on substantial evidence. That just seems to be too attenuated. So anybody who wants to fight me on that, though, I'm happy to meet you on the lists. So,
I saw other hands that were raised. Who else is interested in asking a question? Oh,
Hi there, this is Jennifer Stenger with Duke Energy. And my question relates to, back in the NOPR, the state coordination piece that's pretty heavily prominent in there. Just trying to get your thoughts on how that would actually work in some of these big multi-state regions, and the aspect of the fact that the burden of proof or the burden of getting that agreement or consensus is on the transmission providers.
right. So it is not going to be reassuring to anybody to hear what I'm about to say, which is that I'm not sure how that's supposed to work. And I think we're hoping to get good ideas from people on that subject. In fact, unlike other parts of the NOPR, specific elements were really left open, and comments were affirmatively solicited by the notice of proposed rulemaking itself there. Knowing the variance in outlook among states in the same regions, and I don't think we need to name names, we can all come up with a list in our head, certain amounts of agreement may be achievable broadly on some things, but others I think could be very, very challenging. And what should be required or allowed even, I say allowed, I'm arguing for no further regulation than I use the word allowed, but for people to try to corral all of those cats into a single direction is going to be very difficult. I do not. The implication of your question is not lost on me. I agree. I think it could be very difficult. So, but hopefully, as the NOPR process plays out, we'll have better ideas as to the feasibility and how it should specifically be implemented. So, I wish I had a better answer for you.
Will, I think, had a question.
Thank you, Commissioner, again for joining us. My question is going to be similar to what Jennifer from Duke Energy, and sorry, I didn't introduce myself. William Sauer from Duke Energy. My question is going to be somewhat similar to what Jennifer just asked, but thinking about FERC's actions, you have kind of several parallel tracks. One is a FERC neighbor task force, so kind of these continued discussions with state commissioners. Last one dealt with cost allocation. The upcoming one, I believe, deals with...
I'm sorry, can't hear
I'm
you.
having a little difficulty hearing you.
I apologize. In the upcoming, so going to the FERC neighbor task force
Yeah.
and talk about really parallel tracks that FERC is on. Wanted to get your perspective of how the FERC neighbor task force is going, if it can help, particularly with the question that Jennifer just asked on cost allocation. Speaking, since that was really the focus of the last discussion. Certainly, the next one is interconnection, as you know.
Yep.
Wanted to get a sense
In
from
fact,
you.
that's in a couple days, right? Yeah.
It's certainly off track from when the neighborhood meetings are.
Yeah.
So wanted to get your perspective on how that's going, recognizing that states and both federal partners are key in building transmission and whether it has promise and helping some of the cost allocation items that are kind of particularly prevalent
Sure.
in the NOPR.
So I'm all for the task force. I'm glad that those meetings are being held. I even outside the task force, I very much appreciate talking to the state commissioners about this stuff because they have a completely different view of the challenges of transmission than we do. Right? We truly do have divided jurisdiction, and they deal with problems more immediately in a certain sense than we do. Right? The task force has been valuable because we have some very, very talented commissioners on it, for one thing, and that's always good to have thoughtful people discussing in a forum like that their thoughts and ideas for how to move forward. There's also been a fairly frank exchange of ideas on a handful of subjects. I mean, obviously politely, but usually that's a euphemism for argument. There's no argument during the task force, but there are variant views of every subject brought up. And it actually has turned out to be very collegial between the commissioners on the task force, arguing and going back and forth about specific points. And one thing that I think we can extract from the majority of the comments for the majority of the subject matters we've spoken about is there seems to be an awful lot of enthusiasm for, genuine enthusiasm to try to come up with good outcomes on all the subjects that have been raised, but also a little bit of apprehension as to just how quickly and indiscriminately those plans may be implemented. And I'm being as polite as the skeptics in the task force meeting are right now expressing that, but it's genuine apprehension of you often hear admonitions against one-size-fits-all answers and respect for regional variation. And state commissioners have a particular role where they can say with great moral authority that the citizens of my state, my ratepayers, blank, and because they have that view, the immediacy of their advocacy for their own ratepayers has to be taken seriously. And so when they say that they're a little bit skeptical, nobody said they're skeptical, but when they say let's not rush into things, that itself I think has been an extremely valuable reminder on a periodic basis. And also, it's a very good forum in which to get ideas because we have all of the states' different regimes and different statutory requirements, all of which are being reflected in the discussion. So, I mean, that was a little bit of a rambling answer. So, but does that answer your question? Yeah. Okay.
Drew, I think Amanda had a question as well.
Thank you. Amanda Connor with AP. Actually, Jennifer stole my question, and then I thought I'll ask about the task force, and then Will stole my question there. So I guess I would ask from a personal perspective, do you enjoy the kind of conflicts between federal and state regulation and kind of the puzzle that creates?
It's why I'm in this business. Yeah. So in fact, I will uncharacteristically divert for just one moment to personal stuff, which is because you asked me, do I enjoy? So I really became fascinated with utility law early on because it is the perfect confluence of a handful of different subjects, all of which I really like. One of them is it's technical, and I like that, right? The kind of science-based. The fact is, this business is an engineering one, right? And one of the great redemptive aspects of utility law is that in the end, no matter what we may think about the theoretical bases for actions or non-action, either the lights are on or they're not, and that is an extremely redemptive, clarifying check on any policy that might be implemented. So you have the technical part, you have the public policy part, you have the actual regulatory theory and economics, and then you have the extremely difficult to navigate jurisdictional divisions that are built into the Federal Power Act. And so you end up dealing with fundamental constitutional questions much more frequently than you do in other regulatory regimes. And I absolutely love that. So yeah, the answer is yes, I do.
We have time for about one more question.
Thanks again for coming. This is great. Kevin Heiler with National Grid. Sort of going back to more mundane subject matter, thinking about the conference that the commission is scheduled for October around cost management. I was just sort of taking a quick look at the notice or the preliminary notice that sort of tied cost management to a lot of different subject matter like regional planning or cost recovery mechanisms. Just wondering what your perspective on that conference is, what you might look to get out of it, and what you think we can do to sort of, aside from filing comments, what we can do to sort of put our views most forcefully to the commission.
So at the risk of appearing to be negligent, other than having discussed the subject with my colleagues, and we have talked about it, that is, my life is lived in terms of open meeting cycles. There are 4 or 5 open meetings between now and then. I have not delved into it. I haven't read the preliminary notice yet. So I mean, I know the vague subject matter, but it would probably be irresponsible to start getting into it. So I just have not turned my attention to it yet. And if you saw what was on my desk right now, you would totally forgive me for that. So, yeah. Right. Yeah, and I'm asking for more. Yeah. So anything else you want to?
So just one last question. This isn't actually related to transmission, but it is something that's of interest to this group and other trade associations, which is the NOI the commission has out on trade association dues.
Yeah.
I actually, that is one where we did weigh in on it, and I probably should have captioned it as comments in opposition.
Yeah.
Because there was no debate
It
on
wasn't
that.
hard to extract anything from your comments. Yeah.
I guess I'm curious as to what your thoughts are in terms of, is there a problem? Is this the right way to go about addressing if it is one? What is your perspective on this?
So earlier,
Apart from the
I-
expression on your face.
I realized that with this question that I misled everybody earlier. I said I usually, I pretty much, I don't know if I said usually or always vote in favor of generic proceedings. Well, I voted against that one too. And I think, looking back on my separate statement on that, I think I conveyed perhaps a trace more derision than maybe I should have, but I couldn't believe it. And the idea that that we would give credence to what I felt and I said was a cynical petition. I just can't. I cannot understand why we would do that. FERC's rules are absolutely sufficient for the problem, and if there is an identifiable abuse of them, there are mechanisms by which to remedy it. The trade associations are a basic mechanism by which the speech of the members is conveyed to the commission. It is we rely upon the individual members and on them speaking collectively all the time. The thought that we would somehow ever in our wildest dreams think that it would be appropriate for us to start delving into what speech and how is appropriate is insane to me. I mean, you can tell from my facial expression, I am utterly against this NOI. I do not think it's wise. I think I said in my separate statement that we risk turning ourselves into the FEC here if we start getting into these questions, and I don't want to have any part of that. So, why did we have to end on a note that was that? Because you knew what my feelings were.
I was actually going to say, I'm happy to let that be the final word on the topic.
Yeah.
And
No,
I just want to, we're pretty much at the close, and we have to move on to our next panel. I just want to, I want to thank you so much for appearing here.
I'm happy to be here.
You're very generous with your time. We appreciate hearing your perspective, and thank you again.
Thank you.